How to help an elderly parent make a power of attorney. Learn how powers of attorney can and do bring peace of mind to elders, their loved ones, and their caretakers. These powers enable elders to empower a trusted person to make on their behalf all kinds of decisions about finances and health care. Setting up such powers before a loved one loses the ability to make sound financial decisions can be priceless, especially if the person in need of help is not aware of or denies deteriorating physical or mental health. Watch this video to get a power of attorney for elderly parents. Welcome back, folks, to another edition of City Q. How are you doing today? I hope you are doing fantastic. I'm doing terrific. If you are doing as great as I am, go grab a cup of coffee or tea or vodka and let's roll. Today, I want to talk to you about how to help an elderly parent make a power of attorney. What document will you need? This is the first question. If the person you're caring for is still of sound mind, in other words, they're healthy, everything is fine, they can talk, they can make cognitive decision, they can be comfortable around people, they can socialize, then everything is fine. So if that person is of sound mind, a little forgetful is okay, as long as they can understand the plans you suggest. And if the person is also receptive to the idea of establishing medical wishes and naming someone to handle financial matters, that will make things a lot easier. You can talk to the person, to your relative, you can help the person prepare and finalize both medical and financial powers of attorney. So at this stage, conversation is important, communication is important, making the person feel comfortable, the 3 C's: comfort, communications, and conversation. Financial powers of attorney and health powers of attorney. These documents will name someone, perhaps you, to oversee medical care and handle financial matters and medical matters for that if the need arises. Let me give you a brief overview of both documents. Number 1, medical power of attorney. This document in some states is often called a durable power of attorney for health care. So when you hear the terms medical power of attorney and durable power of attorney for health care, those two terms are interchangeable, so they mean the same thing. So this document names a trusted person to make healthcare decisions for someone who can no longer do so or simply does not wish to. So you have the ability and you have the will. So the person cannot do it or is not willing to do it, the medical power of attorney will kick in. Depending on the person's state of residence, the healthcare representative may be called an agent, attorney in fact, healthcare proxy, healthcare surrogate, or something similar. So all those terms are synonymous. The healthcare agent works with doctors and other healthcare providers to make sure the person who makes the document gets the kind of care he or she wishes to receive. Now, when planning for care, it is very important to understand that the agent has great responsibility. He or she is legally bound to follow the document maker's treatment preferences to the extent that he or she knows what they are. To make healthcare wishes clear, the person you're caring for can use a second type of healthcare document, often called a living will or a healthcare declaration, to provide written healthcare instructions to the agent and healthcare providers. So what you want to do is, if you want to buttress this kind of scheme, you want to have a medical power of attorney and a living will, so that you have a solid scheme, a solid process in place where the worst to happen. To make it simple, some states even combine a durable power of attorney for healthcare and living will into a single form, and that form is generally called an advanced healthcare directive. So I've talked to you about medical power of attorney. Let's now talk about the second important document, which is financial power of attorney. Again, here, folks, we're talking about how to help an elder make a power of attorney. When it comes to power of attorney, we have two categories: medical power of attorney and financial power of attorney. When people have problems, medical problems, when people are getting old. Those are the two areas that the courts and regulators in general pay attention to: healthcare and finances. So let's talk about the financial power of attorney here. The financial power of attorney, in that document, you want to lay out, you want to help your elderly relative write down all the things that matter so that you can help your loved one prepare the form that matters when things go wrong, medically speaking. Now, when you hear the term financial power of attorney and durable power of attorney for finances, they mean the same thing. Those two terms are interchangeable. This document will let your family member or friend give someone else full authority to handle financial matters. The process here is analogous, similar to the durable power of attorney for healthcare. Here, when it comes to a durable power of attorney for finances, this document cedes full authority. The key word here, folks, is full authority, not just partial, not occasional, full authority to the proxy, to the agent, to handle financial matters. The appointed person is usually called the agent, again, or attorney, in fact, though he or she most definitely does not have to be an attorney. This is why the authorities call this attorney in fact. Attorney for a specific program, attorney for a specific occasion. The appointed person, also had the agent for that matter, can handle mundane tasks such as sorting out mail, depositing social security checks, as well as more complex jobs like watching over retirement accounts and other investments, or even filing tax returns. Again, similar to the medical power of attorney, when you have an agent, an attorney in fact, a healthcare proxy, the agent here does not have to be a financial expert. You just need someone who is completely trustworthy and has a good sense of preparation, discipline, and has a good dose of common sense. Common sense is what's really important. Same thing for the medical power of attorney. You don't need to have a medical expert. You need someone who is diligent, somebody who is reliable, and somebody who is trustworthy. If necessary, the agent can even hire professionals to help out with complicated tasks. So if your estate is kind of large, or you have financial matters, financial affairs that are a bit complex, your agent can reach out to other experts who can help him or her sort out your affairs. I'll be right back right after this. Don't go anywhere. Welcome back, folks, to another edition of Sweetie Kiwi. We are still having a conversation here around how to help an elderly parent make a power of attorney. And if you like the clarity and quality of the content so far, please consider subscribing to our channel and turn on the notification bell so that you can be informed in real time whenever we drop a new show. And we do this kind of shows every single day, rain or shine, sometimes twice, sometimes 3 times. It really depends upon our inspiration. Comment below, like, and share this content. What to do if your loved one resists your help? We are all humans. People may disagree with our decision. The thing is, you're trying to help someone. You want to help them medically, financially, but they are reluctant. The elderly relative does not understand. He or she thinks that he or she is not, it is still sound medically, it's still sound mentally. If you think someone who needs help will resist your efforts, you got to carefully consider the way you approach the subject. It's all about etiquette. It's all about courtesy. It's all about treating someone how you would have wanted to be treated if you were in that position. Here is what you need to know about how to get a power of attorney for elderly parents who are resistant to your help. First thing is, explain why powers of attorney are essential. You may have a stubborn dad or mom or granddad or grandfather. You just want to explain to him or her why planning is important. And again, even the word stubborn may not be appropriate here, because people have lived a long life. They're comfortable in their own skin. They're making decisions. They think what makes sense. And we can't just pin the word stubborn on them. Of course, it's all about helping them too, because sometimes when someone is deteriorating mentally, he or she might not be aware of it. So some people may be moved by a request to make powers of attorney because it will relieve anxiety and pressure for you and others who care about them, especially if you have a large family. Even if they don't care much what happens or who makes decisions for them. And you have other people may be more inclined to make health care and financial documents if they understand that doing so is the best way for them to stay in control of their lives, because whomever the name must follow their instructions in every way possible. So if you are able to have a conversation with your elderly parents and explain to them, you might have two scenarios. One may understand and be on board, while the other might be like, listen, no, I'm not going cuckoo. Everything is fine. I'm comfortable here. Don't mess with my affairs. I'm fine. You have to understand, and this is something you want to explain to your relative, if he or she does not name his or her own representatives in powers of attorney, a court may appoint someone to act without their input. The problem is when courts get involved, authorities and judges have the best intentions. They may have the best intentions in the world, but sometimes they have a strict process to follow based on jurisprudence, based on the particular situation, and sometimes their decisions might not be the best for the person. So explain to your relative very well that if he or she does not do what you're telling her to do or him to do, a court might get involved. Of course, when you talk with anyone who's struggling with increasing frailty, you'll have to tread gently around issues of declining mental or physical abilities, perhaps underscoring that planning is a good thing for everybody to do in case help is necessary someday. Everybody. You want to mention everybody. And that's true. You're not really twisting the truth here. Planning is important for the patient, for your elderly relative, for the entire family, for the caretakers, and for the authorities. One thing you want to pay attention to when explaining to your elderly relative why powers of attorney are important, whether we're talking about financial powers of attorney or medical powers of attorney, you want to talk to them about planning. But of course, please never force things. It's just as critical to remember that legally you cannot, and of course you should not force someone to follow a certain course just because you think it's best. There is a legal term for that sort of behavior, for that sort of process, called JURIS. If someone signs a document or acts in a certain way under duress, courts might nullify the act. And duress spells D-U-R-E-S-S. So if you strong arm or coerce someone into making powers of attorney and the documents are later challenged in court, you could find yourself in a lot of legal trouble. So here, I'm not just talking about courts nullifying the documents. You yourself might face litigation and might be on the wrong side of the legal equilibrium here. So the same goes for faking signatures on any legal documents. I'm not even just talking here about durable power of attorney for finances or durable power of attorney for healthcare. Any legal documents in general, if you fake signatures or coerce someone into making a decision, courts will nullify that. So never do it. Never do it. If your relative does not want to cooperate and you eventually have to ask a court for control over his or her affairs, that may be difficult, but trust me, it's much, much, much better than being charged with fraud or forgery. Courts have been very, very strict in the last few years about those cases of fraud and forgery when it comes to estate planning. One thing you want to pay attention to also is that when you have the conversation, if you start the conversation early, when the relative is still of sound mental and physical health, it's much better. Don't wait until the last minute when things start getting a little worse, when physical and mental health is tangibly deteriorating, when the conversations becomes a little complicated. At that time, you want to start when the person is still healthy, quote unquote, so that the conversation can be smoother. You can iron out the most important part, the most important details of the power of attorney, all that kind of stuff. All right, I will be right back right after this. Don't go anywhere. Welcome back, folks, to another edition of Sweaty Kiwi. We are talking today about how to help an elderly parent make a power of attorney. Let's talk now about what to do if it's too late to plan. So if a family member is already incapacitated, you might need to ask a court to name a guardian or conservator to watch over his or her affairs. Again, here we're talking about financial affairs and medical affairs. A court will usually name a spouse or other very close family members to this position, factoring into the equation any evidence of what the incapacitated person would have wanted and other information about what's in his or her best interest. Now, we had a show, we have covered the whole concept of conservatorships and guardianships in an entire show, so you might want to double check that. What I want to mention here is that when you go to a court, when you have to go to a court to get a financial power of attorney or a healthcare power of attorney for your relative, make sure that you are very clear of what you want. Because actually the judge will look at all kinds of evidence before making a decision, but you want the relative who wants to take care of the finances or the healthcare affairs, you want to lay out very clearly the kind of information and the kind of detail you want the court to consider when making a final decision. Clarity always is essential in this estate planning cases. Another thing you want to pay attention to is that conservatorships and guardianships work differently. They are appointed by court. They have a diverse set of responsibilities. Their loyalty, quote unquote, their accountability is to the court, not to you, the family member, which is why you want to, quote unquote, have a conversation with your elderly loved one so that he or she can choose someone who is in the family or someone who is closer to the family, somebody who is trustworthy, right? Usually, I would say by default, a conservator or a guardian is usually trustworthy, but it's more a professional trustworthiness. When you talk about professional trustworthiness, you use the word I'm blanking here. Use the word fiduciary. Exactly. So the person has fiduciary responsibilities. In other words, he or she has to work in the best interest of the client, quote unquote, here, your elderly parent. But that professional fiduciary aspect versus a personal bond, close bond based on trust and loyalty, it's up to you to see what works for you. All right, folks. So we are actually at the end of today's conversation here, and I just want to mention one thing. The information in this show is more informational, educational. We have conducted research and we have gathered all the information in a nice show here. Obviously, this is not legal advice. We're not lawyers. We're not estate lawyers. Our job here is to give you general information you can take into account when making a decision about an elderly parents. If you need specific information or advice, I would strongly suggest you contact a lawyer, an expert, an attorney, an estate attorney, someone who has experience, who has acumen when it comes to estate matters. That person will have full authority, full time, and full knowledge about your situation and can give you advice that best suits your elderly parent's situation. Let's quickly recap today's conversation here. I was talking to you about what documents you will need. So I spoke about medical power of attorney and financial power of attorney. Next, I spoke to you what to do if your loved one resists your help. So you need to explain why powers of attorney are important. So we are in an educational process here, instructional process. and never force things. Never coerce your loved one into signing something. Never forge anything. And the third thing I spoke to you about is what to do if it's too late to plan. If it's too late to plan, then you are transferring authority in this matters to the court, and courts will appoint conservators and guardians based on the situation to take care of your loved one's family affairs, if you will, financial and healthcare affairs. Another thing I want to mention before closing this conversation today is planning. Start early. Have a conversation early when your loved one is still of sound health, medically speaking and financially speaking. He or she can talk to you. You can have a conversation. You can have a report. Because if you start early, then you're building communication, you're building trust, you're building a conversational mode. You're having a dialogue, not a monologue. It doesn't go one way, because once he or she is just has declined mentally and physically, things can be very complicated and convoluted depending upon the loved one's financial affairs, estates, and social ties also. Thank you so much for listening to this conversation. I will see you next time. But until then, remember, stay marvelous.